Sarah Jubb recently said this to Veronica Ferguson. Veronica Ferguson, I hope you will be able to get things sorted out soon. This is so hard to deal with. We keep getting distracted and run over. I am at a loss as to how to proceed with individual cases, including my own. I can only pray that I will be more effective in the months to come. These are two women who are very well known in the family rights movement. They are both known to be very helpful to others who are caught up in the family court racket. Do you notice the futility illustrated by her comment? Again, she said, I am at a loss as to how to proceed with individual cases, including my own. That is a very revealing comment. The reason why it has been so perplexing to millions of people is because you cannot win. It's a stacked deck. I've often made the analogy of saying that it's like walking into a crooked casino and sitting down and playing 21 or blackjack with a crooked dealer who's using a crooked deck. You cannot win. Don Burleson, the best card counter in the world, couldn't win in that situation. He would lose the shirt every day. I know. I know him, yeah. So it's impossible, I believe, to win in state courts, which makes it a great frustrating exercise, one in futility. You cannot receive justice in the state courts. The reason is that essentially all of the so-called family courts are crooked. The vast majority of the judges are literally crooks. So what do I mean by that? I'm saying that the judges are criminals. Criminals are people who commit crimes. In the case of the family court judges, they are in legal terms habitual criminals engaged in a continuous crime. Now, how is that? Those crooked judges violate people's rights with great regularity. They routinely violate people's rights. Some of the more popular or more well-practiced violations of people's rights are illicit gag orders. I'm sure almost any of us know more than one person who has been the victim of a gag order. Those gag orders are imposed upon litigants, warning them not to speak to anyone or reveal to anyone what takes place in that courtroom. Essentially, the judges tell the litigants, okay, just keep a lid on everything that goes on in this courtroom. Just keep your mouth shut, okay? Now, don't be going out and telling your friends or relatives or your fellow church members or your co-workers about what's happening here. I don't want this to get out. And don't even think about talking on Facebook or social media about this, because I'll put you in jail. You see that bailiff over there? He will be happy to put you in jail. And I mean it. Just keep your mouth shut. So that's what a gag order is. And that constitutes an abridgment of a person's right to free speech. The Constitution of the United States guarantees the right to free speech and states that nothing shall abridge that right. It is assured by the First Amendment. The Constitution says that nothing will interfere with, curtail, or block your right to free speech. That is one of the freedoms that is fundamental to America. In some countries, such as North Korea, people do not have the right to free speech. Many of the judges in the so-called family courts have brought that North Korean custom to family court. This is something I'm going to read to you from Fox News. The family of Justina Pelletier, the 15-year-old girl at the center of a custody battle and diagnostic dispute between two of Boston's top hospitals, plans to take legal legend Alan Dershowitz's offer to help. Lou Pelletier told Fox News.com on Tuesday he was thrilled to learn the high-profile Harvard law professor who has won several high-profile court battles, wants to help him win back custody of the girl. Dershowitz also said a gag order imposed by the judge to stop the family from talking to the press was without a doubt unconstitutional. I mentioned that to Randy Davis, and he said, "Wow!" Exclamation point, exclamation point. I said to Randy, "Why don't you jump all over this? The law is your forte. The crooked judges have been on very thin ice for decades. Is it not time that we break that ice?" Randy said, "I'm on it." I said, "Let me know what you come up with, then we all, as a family rights movement, can jump all over it." Randy says, "Yes, sir." Okay, so that is something we need to do. A. Marie, who's known by many of us, said the judge in her case ordered her in court not to talk about her case. I said this to A. Marie. A. Marie, if you have a clear-cut, easily provable case, it should be taken to the highest court in the land, the court of public opinion. Public opinion is extremely powerful in this country. I have seen it. It has happened more than once. I've seen it more than one time, working essentially what would be a miracle. But you cannot appeal to that court without evidence. So if you can find it, find it. My belief is that if we find a good case like you described, I'm talking here to A. Marie, the family rights movement should jump all over it. If it is, as you say, the judge violated your right to free speech, that is a felony committed by the crooked judge. He should be indicted and prosecuted for that crime. If you can clearly show what you said is true, the family rights community should demand that the law be enforced. We should demand incarceration of the crooked judge following a fair prosecution or plea bargain. Another trick of the crooked judges is to deny the right to jury trials. The right to a jury trial is guaranteed by the 7th Amendment of the United States Constitution. The states have cooperated with the violation of the rights of the American people by passing state laws or statutes that say a person cannot have a jury trial in family court. This is in direct conflict with the Constitution of the United States. It contradicts the Constitution of the United States. In this country, there is something called the Supremacy Clause. That is a governing tenet of the American legal system. It clearly states that there will be no law that counteracts, contradicts, or overrules the Constitution of the United States. The Constitution of the United States is the supreme law of the land. That means that no county ordinance can be passed, no courthouse custom can be adopted by the judges, or no state statute can be passed in contradiction to the Constitution of the United States. Any such thing is a legal figment of the imagination. It is a legal abomination. It is criminal. My youngest son was sworn in as an attorney this year, and I was at that ceremony, and I was listening very carefully to what it was that he was swearing to, and because some of the people who deal in a lot of exotic law, say that these attorneys swear allegiance to all kind of things, the Bar Association, the Illuminati, everything. And so I was listening. I want to hear exactly. Really what they swear allegiance to is the Constitution of the United States, and this is in North Carolina, and also to the Constitution of North Carolina, in so much as the Constitution of North Carolina does not contradict the United States Constitution, and to demean himself as an attorney, which act nice. So that was it. So I was pleased that there wasn't all this exotic stuff thrown in. The judges and their accomplices may ask, so what if people's rights are violated? Some of the judges in the family courts will actually tell litigants, the Constitution has no place in my courtroom. Many people in the family rights movement, in addition to the crooks in the family court racket, have suggested that the judges have immunity meaning absolute immunity. Do they? Do the judges have immunity if they violate people's rights? Can anything be done about it if they violate a person's rights? Well, why don't we consult the law to see what the federal law says about it? The law that is pertinent to this matter, us, our movement, this gigantic national problem, is U.S. Code Title 18, Section 242. I will read it to you word for word. U.S. Code Title 18, Section 242. This nation needs a countrywide movement by the American people to indict, prosecute, and incarcerate this is me talking, crooked judges in the so-called family courts and their accomplices for their crimes against the American people. Okay, here it is. U.S. Code, Title 18, Section 242, federal law pertinent to this matter. Deprivation of rights under color of law. Section 242 of Title 18 makes it a crime for a person acting under color of any law to willfully deprive a person of a right or privilege protected by the Constitution or laws of the United States. For the purpose of Section 242, acts under color of law include acts not only done by federal, state, or local officials within their lawful authority, but also acts done beyond the bounds of that official's lawful authority. If the acts are done while the official is purporting to or pretending to act in the performance of his or her official duties. Persons acting under color of law within the meaning of this statute include police officers, prison guards, and other law enforcement officials, as well as judges. It's right there, black and white in the law. Care providers in public health facilities, and others who are acting as public officials. It is not necessary that the crime be motivated by animus toward the race, color, religion, sex, handicap, familial status, or national origin of the victim. The offense is punishable by a range of imprisonment up to a life term or the death penalty, depending upon the circumstances of the crime and the resulting injury, if any, period. That's the law. Now, what goes hand in hand with U.S. Code Title 18, Section 242 are Rules 3 and 4 of the Federal Rules of Criminal Procedure. Rule 3, the complaint. The complaint is a written statement of the essential facts constituting the offense charged. Except as provided in Rule 4.1, it must be made under oath before a magistrate judge, or, if none is reasonably available, before a state or local judicial officer. It has to be in writing. You can't just whisper to somebody in the hallway. Doesn't say it has to be in any particular form, anything, any fancy way of laying it out. Although I was talking with Chris Hallett, and we both seem to feel like it would be better to type it up and make it look real nice and official. But it doesn't have to be. All right, so Rule 4, arrest warrant, like that, arrest warrant or summons on a complaint. A, issuance. If the complaint or one or more affidavits filed with the complaint establish probable cause to believe that an offense has been committed and that the defendant committed it, the judge must issue an arrest warrant to an officer authorized to execute it. At the request of an attorney for the government, the judge must issue a summons instead of a warrant to a person authorized to serve it. A judge may issue more than one warrant or summons on the same complaint. If a defendant fails to appear in response to a summons, a judge may, and upon request of an attorney for the government, must issue a warrant. That's it. It's pretty clear cut. Now, what if the federal magistrate judge, upon receiving a federal criminal complaint, elects or chooses not to issue a warrant or even a summons? That judge then engages in dereliction of duty, in obstruction of justice, in malfeasance, misfeasance, and nonfeasance. He could subject himself to prison by doing that. So, now, I wrote a procedure for this back in the 90s. and which I think would greatly enhance the likelihood of the federal magistrate judge going ahead reluctantly and issuing the warrant. In the event that the judge, despite of what we do, refuses to issue a warrant or a summons, then we need to engage in public protest, peaceful public protest. We should, my suggestion would be that we already have the signs made the night before the presentation is made, and so we don't have to wait around for people to make the signs. The refreshment, people on the refreshment committee should already be assigned, and this should not be a 2-hour event. In the event that we have to protest, we should be protesting outside the federal courthouse. Some of the signs should have the name of the federal magistrate judge who is refusing to perform his duty for which he's being paid, and his responsibility to the American people. And of course, some of the signs should have the name of the offending judge who violated a person's rights to begin with. Criminality under color of law. Color of law refers to an appearance of legal power to act, but which may operate in violation of law, which is what we're seeing every day. For example, though a police officer acts with the color of law authority to arrest someone, if such an arrest is made without probable cause, the arrest may actually be in violation of law. That's why it is a federal crime for anyone acting color of law to willfully deprive or conspire to deprive a person of a right protected by the Constitution of U.S. law. Color of law simply means the person is using authority given to him or her by a local, state, or federal government agency. Deprivation of rights under color of law. Section 242, Title 18, makes it a crime for a person acting under color of law to willfully deprive a person of a right or privilege protected by the Constitution of the United States. Now, I got to wondering a while back, these people engage in crime on a regular basis. I was wondering, well, how do they compare with other legendary criminals in our country? People like Jesse James and John Dillinger. How do they compare with those folks? And Bonnie and Clyde. So I looked it up. Now, it has been said that in a busy week, some of the divorce court judges, a busy week, not a regular week, but a real busy week, may commit over 100 felonies against American citizens under color of law. That is a lot of crime. There is little doubt that the crooked judges are the biggest crooks to ever enter the courtrooms. John Dillinger, an infamous bank robber during the Great Depression, is believed by historians to have robbed 24 banks and 4 police stations. Each of those robberies was a felony also. That's a total of 28 during his career. Jesse James is said to have robbed 7 trains, 12 banks, and for a total of 19 felonies. Bonnie and Clyde are said to have robbed a dozen or so banks and a number of small stores and rural gas stations. So all of these robberies by these criminals, all put together, are less in number than a single crooked judge is subject to commit in just one busy week. And so do the math. Suppose on a typical week they're committing 40 felonies. All right, if they're taking 2 weeks of vacation off a year, that leaves 50 weeks that they're on the bench committing these felonies. So 50 times 40 is 2,000 felonies a year. Well, if a judge was on the bench for 10 years, that's 20,000 felonies. That's a lot of crime. And they're not being prosecuted for any of these crimes, which is an absolute tragedy. That's why we're all out here getting sick in this cold weather, and people who would love to be here are not here, but are engaged in this movement. This is a very rapidly growing civil rights movement. And I can tell you right now, that growth is not going to slow down because of people like the ones that you see right here today. And we had the privilege of meeting in Washington, D.C. last September. Why are these habitual criminals who are engaged in a continuous crime allowed to sit on the bench. Okay, and why are they not sitting in prison? The reason is that they are being protected by the judges over them. It's kind of like the Mafia, where you have criminals protecting their fellow criminals. This is not only a scandalous situation in this country, it is absolutely horrendous. The social carnage that has been inflicted upon the American people by these crooked judges is terrible. It is almost without precedent, probably is without precedent in this country. Connie Reguli, she likes to pronounce her name Reguli, wrote this: "Justice without power is meaningless. Power without justice is tyranny." I responded to Connie saying, justice without power is meaningless, power without justice is tyranny. The power of the crooked judges lies in the cops. Just as the regular mafia has its enforcers or muscle guys, the legal mafia has its enforcers, who are the cops. The cops are being ordered by the crooked judges to assist them in violating the rights of the American people. I believe that the police union should be an ally to the people in the family rights community. I'm sure that many of these police officers do not like violating people's rights, because in some cases it's happened to them or their fellow officers. Like Hitler's Nazis who participated in the Nazi Holocaust, our cops are paid by the people, who are paid by the people, are participating in the American Holocaust. Back in the day of my campaign in my newspaper against the crooked judges, a plainclothes police detective approached me at a Wendy's where I usually had lunch. We had a long visit. He told me that many in the police department agreed with the things I published in my paper. He told me that the police refused to enforce the court orders of the crooked judges. He said, "We aren't, it's the sheriffs." So I told him that he should band together with like-minded officers in the police force, and they would become a powerful force. And by the year 2000, now this happened to me, first happened to me January 9th of 1995. And it went on for about 2 years, not 18 years. But the reason for that is because I owned a newspaper and I'm a pretty good writer. I put a lot of heat on those suckers. Yeah. Okay, so if the police in Charlotte refuse to violate the rights of their fellow citizens, cops throughout the nation could also. If Hitler's military had refused to slaughter the Nazi Holocaust victims, 6 million Jews and Gypsies would not have been murdered. You have an inkling of how many thousands of fathers, mothers, and children have committed suicide as a result of judicial corruption in the so-called family courts. Nobody's ever going to know exactly how many people, because to do that you'd have to interview every person who's getting ready to commit suicide, and then he would maybe swear a notarized affidavit of why he's committing suicide. That ain't going to happen. But it can easily be surmised. I know when I was in Washington in the year 2000, I was told that approximately 5,000 men commit suicide every year. That's a lot of folks, because every September, we kind of go into a national mourning over the 2,300 people the Americans who were killed in 9/11. Well, you contrast that 2,300 with 5,000 the same year, and 5,000 the year before, and 5,000 the year before. Even just the 5,000 every year since then, I think it comes out to like 85,000. But nobody ever seems to be concerned about those folks. And now it's not just men, it's got a lot of women committing suicide. Jody Mueller from your state, Jeff, can tell you a whole bunch of women who have committed suicide. In fact, I asked her, 2 women in the movement who are known by many of us were talking to me about suicide in the last year, and I called Jody and asked her to call them, and they didn't commit suicide, so it was good. May the carnage soon come to an end. President Trump can end it. If he does, he should have our full support as a great American hero, which is exactly what he will be. And I believe that he is going to do that. I believe that he has been coming, since he took office, step by step by step in our direction. There are those in this movement who agree that we're kind of holding back. We're waiting to see some concrete steps on the part of the president that he is going to help us, and then we can have his back against the Clintonites who have been attacking him 24/7 ever since he won the election, even before he took office. I was having this conversation with Brian about a year ago, and I said we could become the Trumpeteers, and he liked that term. Okay, so why are the crooked judges doing all of this? They're doing it for what the Bible refers to as filthy lucre. They're doing it for money. And my GPS ran me around on a goose chase for about 2 hours before I got here, so I didn't get to hear all the speakers. But I would assume that some of the folks who spoke previously addressed the subject of Title IV D&E funding, in which the financing of this family court racket is done by money which is stolen from the Social Security Trust Fund. Politicians have been saying for some years now that young people will not get to retirement because the Social Security Fund is running out of money. Your retirement has been stolen. I would think that the young people of this country would be natural allies to the family rights movement. I know both my sons were active in the Ron Paul Army in the presidential campaigns of 2008 and 2012. And the Ron Paul Army had the best ground game in politics. And the reason is young people have a lot of enthusiasm. You know, whenever Romney was running, the Romney people would sit back in a hotel room or some office and munch on things and talk to each other, and every once in a while make a robocall. Well, these young people were out knocking on doors. And I went out with my youngest son, who just become an attorney. And I was a media observer embedded with the Ron Paul Army. And it was a beautiful day like this. And we were out knocking on doors and talking to people. And that's what young people would do. How helpful would they be if they were to join this movement? And they should join this movement. They have a whole future at stake. Who wants to be broke when they retire? I don't think anybody does. So I'm going to make, at this point, I'm going to have a quick recap of what we've covered so far. All right, this in essence is the issue at hand regarding the family rights movement. It is a rampant violation of the rights of American citizens, which has not been addressed, to the great detriment of the American people. In order to facilitate the family court racket or to make it appear legal, states have passed laws to accommodate the operation of the racket. One such law in many states is that litigants are denied the right to a jury trial in the so-called family courts. This is an absolute violation of the 7th Amendment of the United States Constitution. It is clearly in violation of the rights of American citizens. However, it makes it very handy for the family court racket to continue in its abomination against the American people. Litigants are free to demand a jury trial, of course, but in the cases in which they do, the judge denies their right to a jury trial. When a judge does that, he is committing a felony against U.S. Code Title 18, Section 242. That federal law makes it a felony for any government agent to violate anyone's rights under the Constitution of the United States. The crooked judges who commit these crimes should clearly be indicted and prosecuted for their crimes against the American people. By denying the person's right to a jury trial, the judge establishes himself as judge, jury, and executioner in the case. That means he is free to do anything he wants under color of law. The judges in those lower courts violate people's rights on a regular basis. Not only do they deny jury trials, they issue illicit gag orders to try to keep their skullduggery a secret, hidden from public scrutiny. They also engage in numerous violations of the right to due process, and they engage in the constitutionally banned practice of debtor's prison. The last issue of my paper is still online, and page 7 has a full-page editorial by Phyllis Schlafly that addresses that particular subject. Up in Charleston, South Carolina, a few years ago, they had this film clip they kept showing over and over on television, in which a cop stopped a black man who for having a broken tail light. So the cop went up and talked to the guy, and then he went back to the cop car. Well, the black guy jumped out of the car and started running away. And the cop just went, pew, pew. He shot him in the back 9 times. He killed him on the spot, and then the video showed he was planting evidence. So I thought, well, this is so weird. I mean, a broken tail light, I mean, that's not that big a deal. And so that was all it said initially, but a couple of days later, they said, well, there was a warrant out for his arrest. They never said another word about it. Phyllis Schlafly tells what the warrant was for. The man had been put into debtor's prison twice already. He didn't want to go back to debtor's prison. The horror that has been inflicted upon millions of Americans in these kangaroo courts has been enormous for decades. Hundreds of thousands of moms, dads, and children have committed suicide as a result. Citizens routinely go broke by spending their money and financial resources in their efforts to get their children back, who have been stolen by the crooked judges. Many become homeless in the process. The children who are kidnapped under color of law undergo great personal damage. Not only do they suffer the tragedy of being taken from their families, they are frequently abused physically, sexually, and chemically in the foster care industry. The President of the United States, Donald Trump, should act on behalf of the American people by instructing his Attorney General, Jeff Sessions, to perform his duty to the American people by indicting and prosecuting the crooked judges. The family rights movement should have a mission statement, a goal that needs to be accomplished on behalf of America. That mission statement should be, in my opinion, enforce the law, prosecute crooked judges. Pretty short and sweet, very succinct. Enforce the law, prosecute crooked judges. When that happens, the family court racket will fall apart like a house of cards. I do not believe that the family court racket is going to end until that occurs. So what are we going to do about ending this very dark chapter in American history? Needless to say, this has been a great concern for family rights activists for the 23 years since the judicial corruption in the family courts was inflicted upon me. There have been multiple points of view regarding this question. There have been many people crying out for reform during this time. Although essentially no progress has occurred along this line, that refrain is still heard very frequently. The fallacy of reform. The past 2 decades of futility in the family rights movement have seen the vast majority of family rights activists crying for reform of the system. The reformers seem to think that if legislators are lobbied long enough and hard enough and by enough people, something might be done that might alleviate some of the enormous suffering that has been inflicted upon the victims of the family court racket. That is true. Something might possibly be done if enough time, effort, money, and lives and decades are spent on that continued attempt. Unfortunately, over 20 years and counting has shown almost zero improvement. Getting legislation passed that would be meaningful is enormously difficult. Even if something was finally passed, following the great compromise legal process, it would be likely very, very watered down. In the meantime, during this lengthy ordeal, millions more lives would continue to be destroyed. Countless FRAs, meaning family rights activists or advocates, will continue to become penniless, become homeless, become suicide victims, or all three. This is a very long line if you would like to be in it. There are plenty of openings. Continued futility only leads to more victims. The reform approach is predicated on the false notion that this nation needs some more laws to deal with the family court racket. That is an incorrect premise. There is plenty of law already on the books. We've already talked about that today. They should deal very effectively with the problem. Put them in prison is a solution to the problem. When a crooked judge goes to prison, he is not going to continue violating people's rights. There is a widespread misunderstanding of what the problem is, even among FRAs. The vast majority think that what has happened to them is a matter of misunderstanding of their case, overreaching or unfairness by the judge. The FRAs have been led to believe by the moles, lawyers, and judges that the judges acted against them in legally acceptable ways. That the judges are simply using their legitimate discretion and that they have absolute immunity. We've seen today that that is an absolute crock. Okay. They think that repeated filing of motions and appeals will make things right for them. They entertain the notion that if they file just one more time and dot a few more I's and cross a few more T's, they will receive justice. That is a very incorrect assumption, which is based upon the idea that the judges involved are good, honorable people who have a propensity to do the right thing in accordance with the law. That is a very false and costly mistake. Going along with that point of view and approach has cost the American people enormously. This is the problem. The judges involved in the family court racket are crooks. They violate the law on a regular basis. They violate the rights of American citizens. In so doing, they are committing felonies pursuant to U.S. Code Title 18, Section 242. They are not being indicted and prosecuted for their numerous crimes against the American people. The solution is that the family rights activists and advocates should collectively demand that the crooked judges be indicted and prosecuted for their crimes. The American people need to demand that the law be enforced. Why should the law not be enforced? In this country, we hold to the notion that no one is above the law. Look at Richard Nixon. He was driven from office as President of the United States because of trying to cover up the Watergate fiasco. When the crooked judges go to prison, the family court racket will come tumbling down. The myriad of abominations that are inflicted upon the victims of the family court racket stem from illicit, rights-violating court orders issued by the crooked judges. Those illicit orders are criminal. They are felonies. Another inadequacy of seeking reform is that even if something is successfully tweaked somewhat with the new law, that would only help a little going forward. It would do nothing for the existing or past victims. It wouldn't get anybody's kids back or put any crooked judges in prison, undo their crimes, or redress any prior felonies committed. What is really going to bring victory for the American people, meaning to bring down or put out of business the family court racket, is collective activity on the part of us. I have seen that happen more than once. Just a couple of months ago, one of our condo mates in D.C., Paul Cummings, was in El Paso County, Colorado, at a hearing that he called for. And Jamie Vigil, the magistrate, started misinterpreting the law. And he corrected her. I don't think he did that in an offensive way or anything like that. She didn't like that. She put him in jail. He was in solitary confinement for quite a while. Then they took him out and they put him into a mental wing of a hospital. And one of our folks from Texas called me and told me where he was being held and the phone number for the hospital. Okay, upon receiving that information, I called Ted and gave him that information, And so Ted says, okay, I'm going to call right now. And he did. So after about 5 minutes, I thought, well, I'm going to call. So I called, and one of the staff members at the hospital says, well, he'll call you right back. And at that moment, I received a text from Ted saying that he was talking to Paul right then. So about 5 minutes after that, Paul called me. We had a pretty long conversation, which I ended. I says, okay, there's something I want to do. And as soon as I got off the phone, what I did was I contacted people, family rights activists all over the country that I know, and gave them that information. This is where he's being held, and this is the phone number. Now, the reason I did that is because something similar to this happened in the 1990s. There was a fellow by the name of Christopher Robin, that's actually his name, in L.A., who lived in Clark Gable's old mansion. They call it the Purple Heart House because there was this big wall around the mansion, and he would go out every day and draw a Purple Heart on this wall. And there were hundreds of Purple Hearts, and each one of those represented the day that he was without his child. So one day Christopher Robin hung, I think it was a judge, in effigy on his property. Well, they went and took him and they put him in the funny farm. Well, I found out about this, so I contacted people all around the country. We didn't have Facebook then, okay? And there was such a deluge of public pressure on the hospital, they let him go like a hot potato. They were planning on keeping him there for months. They couldn't wait to get rid of him. So I figured the same thing would happen in El Paso County, Colorado, and it did. People were calling them all night long, and by the next morning, the people at the hospital were saying, y'all are harassing us, leave us alone. And they let him go. Chris Howlett called, he read the Riot Act to him, he read the law, it was pertinent. They let him go post haste. They were going to transfer him to a regular mental hospital and keep him there for a long time. So collective action is very powerful in this country. And the more we practice it, the greater success we will have. I formulated something, put together a formula recently that someone was just telling me earlier they likes, which is the law, which has been on our side forever. I mean, back in the 90s, U.S. Code Title 18, Section 242 was on the books, okay? The law plus public pressure equals victory. Neither alone will get us what we want. The law has always been there, but that hasn't brought us victory. It has to be combined with public pressure. There is a kind of a progression, I believe, toward our goal in the family rights movement. This movement, although it is very rapidly growing, is still in the early stages, the way I see it. What is important right now, step number one is public education. That is incumbent upon us to educate the public, the general public, and even politicians. Because I believe a lot of people in the movement say, "Oh, all the politicians know all about this." I don't think that's true. A lot of them do not, and so we can educate them along with the general public and the media. Some people say, "Oh, the media know all about this." I don't think that's true either, but we can clue them in. This is a good way to do it right here. This is something that actually Donald Trump liked on Facebook. I wrote this about a year ago. So actually it's an update for something called the handout, which Jody Mueller, I believe, has personally given to every legislator in Iowa and in Texas. And it was a one-page document she's printed on both sides, and she's posted them on the bulletin boards. And so then she and Rosa Drach and Diane Lyons were imploring me about a year ago to write another handout. I just call that one the handout, about the child trafficking racket, because that original did not address that. And I finally just said, look, I don't know about this. You guys are just telling me about it. And so I said, what y'all need to do is get together and write it, and then I'll edit it for you, and it'll sound really good. And they did not do that, so about a week later, I wrote this. I titled it Travesty and Abomination, The Call to Action, based on what they had told me. And then shortly thereafter, Donald Trump liked this on Facebook, and everybody said, wow. I said, well, he should have liked it. It mentions him. He likes to be mentioned. So, in this, even though it's just one page, I formatted this before the Million Parent March in Washington last September to be printed as a bifold handout. It's one piece of paper printed on both sides and makes it like 4 little pages. And it is is quite a good educational piece. A person who knows absolutely nothing about the family court racket can read that in, I don't know, a minute and a half or however long it takes and become quite knowledgeable about it. So public education is very important to us right now. Then public education will bring public awareness. Public awareness will bring public scrutiny. Public scrutiny will bring public pressure. That's what happened with me in my paper in the 90s. And by the year 2000, the entire court system in Mecklenburg County changed. And Mecklenburg County is a very populous area. It used to be, in the 80s, it was the 5th largest market in the United States, and it's grown a lot since then. So, and public scrutiny will bring public pressure, and public pressure is what will bring down the family court racket. And that can happen in 2 ways. One is for us to be hitting the streets if necessary and engaging in some of the things I mentioned earlier. And the other is for President Trump to arise as a champion of the American people, which I think is going to happen, because I believe that he has been coming step by step by step in our direction ever since he took office. So I think that it's going to come. It can come either way, either of those 2 approaches. But I believe that if, and I believe that the way to really do this about the judges is to choose certain cases in which the violation of a person's rights is crystal clear from the cold record. It's right there in black and white. Anybody can see it, that this judge issued an illicit gag order against that citizen, or denied him a jury trial. And some people do demand a jury trial, and they are denied that. That's a denial of the right. That's a violation of their rights. And in those cases, we do need to come collectively together to focus on that one particular judge. It is a divide and conquer strategy. Now that is exactly what has been used against all of us. Just some poor little American litigant is thrown into these divorce courts or family court, and they are met by a whole cadre of crooks that are jump all over them. It's just like throwing a Christian to the lions. The Christians don't have a chance, and neither did any of us. And neither did all those millions of people who are not here today. The same thing has happened to them. So it's been a very successful strategy to divide and conquer against us. We can turn the tables on these judges and go after them one at a time, and I don't think it's going to take very many of them going to prison before that racket falls apart. So thank you very much for everybody coming out today. I hope that nobody gets sick from being out here in this chilly weather. I hope we'll all get something nice to eat and warm up, and I hope that we will increasingly come together. The people of this country are increasingly coming together. We are going to win this war. Thank you.
Thank you, Don.